topic of this video is the Eighth Amendment, which is, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. What this means is that the Eighth Amendment prohibits the federal government from ruling harsh penalties on criminal defendants, and that the factors of cruel and unusual are the most controversial in meaning, since there is no concrete definition of cruel and unusual. So these are the questions: what punishment is cruel? How do we measure cruelty? And why does it matter if it's unusual or not? The death penalty, or capital punishment, has very much evolved throughout the years. The death penalty has been a part of our judicial system since the United States was created. There have been lots of changes and different viewpoints on this subject, and in this video we will go over them, involving timelines, the idea of evolving standards, interviews, and different court cases. There are 5 different ways to conduct the death penalty. Going from oldest to the most modern include caning, the electric chair, a firing squad, gas chamber, and now lethal injection. Starting in 1790, we begin the history of the most important aspects of the death penalty. So, in 1790, Thomas Byrd was the first person in the United States to be executed, and he was hung. Following in 1890, William Kemmler became the first person to be killed by the electric chair. In 1911, the firing squad was introduced as a method of execution, and then 13 years later, in 1924, cyanide gas was introduced to be also used as a way of capital punishment. In 1958, the controversial Trope versus Duels court case came forward with the issue of evolving standards, meaning that society's viewpoints on the death penalty had changed since the original aspects were put in place. In 1966, capital punishment lost popularity with the United States and had an all-time low of a 42% approval rating. In 1977, Oklahoma becomes the first state to adopt the most modern form of capital punishment, lethal injection. In 1988, the Supreme Court finds that the execution of kids 15 or younger is considered cruel and unusual in the Thompson v. Oklahoma court case. In 1989, in Henry v. Lionel, executing those with mental disabilities is stated as being not a violation of the Eighth Amendment. But a few years later, in 2002, the Supreme Court then found that the execution of those people with a mental disability was considered unconstitutional. In 2005, in the Roper v. Simmons case, they found that the executions of minors was now considered cruel and unusual, so the age was raised from 15 to 17. Nowadays, many states choose to sentence inmates to life without parole instead of pursuing the death penalty, due to how long the process takes.
The numbers: 31 states have the death penalty, 19 do not. 4 states with gubernatorial moratoria: Colorado, Oregon, Pennsylvania, and Washington state. Here are executions by state. The U.S. total since 1976, about over 1,400. Texas has done 542, Oklahoma 112, Virginia the same, and Florida 92, Missouri nearly 90. The U.S. executions since 2013, in 2017, the number is 7. In 2016, that is has gone down from 20 in 2016, 28 in 2015, 35 in 2014, and 39 in 2013. Jessica Brand, what's happening? Why are we seeing this trend?
Sure. I mean, I think we see, obviously, public opinion really starting to decline, and
I believe that the Eighth Amendment relates to capital punishment, cruel and unusual punishment, death penalty, things like that. Yes, I do believe that capital punishment is constitutional and legal under our system of government. I don't have any issue with lethal injection, although I know that they have had some issues with it. I believe that those can be resolved. And quite honestly, in terms of something that's not cruel and unusual, I don't think anything is faster than a firing squad. I know that there are some death row inmates who have requested firing squad, whether that is for the shock factor of people who disagree with the death penalty, or if they really understand that it is painless as far as we know. Those are the two things I think of most often. Well, I can remember as a young man that there were gas chambers, and people were put to death. Specifically, I remember California being a gas chamber state. I also remember electrocution. That wasn't that long ago, and I think that the death penalty being carried out by lethal injection is a more recent act, maybe in the last 15, 20 years. So those are the things that I remember most.
I do not think capital punishment is constitutional. I think lethal injection would be the most humane way. I do not think we should keep the death penalty, just because I personally don't think it's a humane way for us to live, and I don't think it's constitutional. I do think inmates should have the right to how they are put into death.
In the famous 1958 Trope versus Dulles court case, the Supreme Court found that the punishment given to a criminal for their crime has to be comparable to what they committed. This is the idea of the principle of proportionality, meaning that there's going to be a different punishment for someone who robs a gas station of a candy bar than someone who goes out and murders another person. In 2004, in the court case of Roper versus Simmons, the Supreme Court found that it was unconstitutional to apply the death penalty to minors. This was based on the idea of evolving standards, meaning that Americans' opinion of cruel and unusual were changing based on what they used to be. So what used to be considered not cruel and unusual, such as executing a minor, was now considered cruel and unusual.
Though is in the evolving sense of decency around how we punish juveniles. Is the juvenile death penalty appropriate for someone who committed a crime at the age of 17 or younger?
What do you mean by evolving?
Well, what happened back in '89 was the Supreme Court said, look, if it's an offender under the age of 16, it simply is not appropriate punishment to execute that individual. Now we need to look at what's happened in the past 15 years in terms of the opinion across the country, what we know about the development of youth, their brain development, their capacity for making decisions, their maturity level, and whether this is still good law. That's why the Supreme Court is hearing this case, to take another look at that capacity issue of these offenders, whether the death penalty is appropriate or whether it is indeed cruel and unusual punishment.
Mr. Newsom.